Authority, Mr. Pina.
May it please the court. And pardon me, Your Honors, my hearing aids are malfunctioning. I'm going to remove them if I may.
Sure.
My name is Edward Pina, and I represent the plaintiff appellant, Gary Schindel, in this appeal. We firmly believe that a careful reading of the district court's dismissal of Mr. Schindel's hostile work environment claims and retaliation claims under the ADEA cannot be supported, and that the court misapplied Rule 12b-6 precedent, which is stringent. Mr. Schindel delineated clear, plausible allegations of having been working in a hostile work environment based upon his age, at that time 62, at the time of his demotion, and that's a demotion of over $50,000 per year, from 164 to 114 or 13, so a significant demotion. And at that point in his career, as we all know, Your Honors, pensions and retirement compensation are usually determined by the high 3 or high 5 years. So this was a devastating demotion to my client. And if you get into the facts alleged for the demotion, they are simply not there. And the district court, we simply did not get the district court's attention to that. The district court makes credibility determinations. It's the only way our district court could have come up with a dismissal, a pre-discovery dismissal of Mr. Schindel's hostile work environment claim and retaliation claim. As you know, and we all know this about the high standards for 12b-6 motions. They're only appropriate if the plaintiff pleads enough facts to state a claim that are plausible on their face. We're all good with that. Schindel pled more than sufficient facts to allow the court to draw reasonable inference that the defendant is liable for the misconduct, and yet we have a decision that doesn't do that. We have a decision.
Is it your position that the incident regarding the sinkhole was not an adequate reason for some kind of adverse employment action?
It is. It is. And
it is sufficient or is not sufficient?
It is not sufficient. It was bogus. And all of the people that were at the inspection, the 3 geologists that were at the inspection, were never asked their opinion before the director demotes him, proposes to demote him. Didn't interview them. If he had interviewed them, he would have known that the 2 geologists that allegedly made a descent, one made a descent of 2 feet, which is literally stepping into a culvert and looking around, and the other one made a descent of 5 feet. And even with the 2-foot and the 5-foot descent, they were wearing full safety gear, full harnesses, full retractable equipment, helmets, the whole 9 yards. Why? Because he was mentoring them. He was using this as an opportunity to mentor younger geologists in how to do this safely and how to always do it safely. He takes this very seriously. He was president of his professional association at that time, and this was something that they had been looking forward to for quite some time. Also, Mr. Schindel had convened planning meetings, one or two planning meetings a month before, and of course the director that demoted him never attended them, never showed any interest in them, and never went to the site, and never interviewed the persons that he claims that Mr. Schindel put in harm's way. He never interviewed them. He never interviewed them until after Mr. Schindel files an age complaint. When HR interviews them at that point, after the EEO complaint, both were interviewed independently, and both scoffed at the idea of being in danger by stepping into a 2-foot culvert and looking around, and climbing down a 5-foot culvert, looking around, looking to see, making sure that her mapping information that they had was still accurate, that none of the pathways had been blocked, and then she goes back up. She's pulled back up, and all the time, the whole inspection team is right around her, looking at her, and she is, of course, because of Mr. Schindel's mentoring, wearing all of the proper safety equipment. As I said, they were not interviewed until well after the incident. Didn't bother to talk to them before he demoted this gentleman to the extent of 30% of his pay for the rest of his life.
So what is the indication in the record that that was because of age?
There had been a prior incident where Mr. Schindel was demoted without a loss in pay, where he had been head of a department, and this new director, when he gets the position, he interposes someone between them. Now, there is no loss in pay. Mr. Schindel's not pleased about it, but he is the boss. He is the new boss, and doesn't make a complaint about it. And before that, there was an instance where he was reprimanded by this, at that time, brand new boss, Mark Hamilton, and he was reprimanded for speaking to the press without authorization. And Hamilton had been consulted by Mr. Schindel and told, I've been asked to give an interview, and Mr. Hamilton decided that no, they were not going to give any interviews. Well, that media ran a 10-year-old archival piece, and they identified it as a 10-year-old archival piece, not a new interview. He still reprimanded Mr. Schindel. Mr. Schindel says, well, I didn't give an interview. I followed your instructions to a T. He didn't care. He didn't care that his reprimand was false.
You still haven't told us, though, what any of that had to do with age or age discrimination.
Well, he's at this point 62 years old, and he's also noticing that other 60-year-olds and persons in their late 50s are being targeted. Now, and we're talking about the Edwards Aquifer Authority, which I believe is it's a public entity. There's no question it's a taxpayer-supported, permit-supported public entity with about 100 people. So when you see, and this goes into, now if we move forward into the summary judgment stage, we can get into some of that evidence. We see that there are 12 people that are being terminated, not retired. There was, I think, 2 people that did retire and appear to have been retired of their own accord when they reached 65 or so. But aside from them, there's 11, and with Mr. Schindel, 12 people that were being forced out or terminated in their 60s. And then there's another 4 that were terminated in their late 50s. So, that's a attention grabber. If you've got a small agency with 100 employees and you have a large chunk of them, now you're at about 15 that are over 55 or more that are being let go within a couple of years. So they start looking around, and it was not until the summary judgment evidence was collected through discovery that we did learn from one of them. By the way, one of them that was not disclosed to us by the EAA in our discovery requests. And he's the one that tells us that Mark Hamilton was comfortable making ageist remarks and had been doing so for quite some time. And the record shows that he would refer to John Craddock, the witness, as old guy, and he would refer to Mr. Schindel as old guys, and refer to other 60-year-olds as old guys, and would say things like, we need to get some new blood in here. We need to reinvigorate this place. We can get 2 guys for the price of one of these old guys. Well, that set the tone. When you've got an executive director talking like that, it sets the tone. It sets the tone of what is acceptable or going to be tolerated. Like I said, my client was not aware of Craddock's experience at that time until the discovery process. But so now if we can move on to the summary judgment dismissal, or dismissal on summary judgment. So past the 12B6, now we're on the 56, Rule 56. We have a considerable amount of age-related language and conduct, such as, with regard to Mr. Schindel by Mr. Hamilton, Mr. Schindel, he was a co-founder at the EAA of a mentoring program for college students. They were trying to get more geologists and geoscientists into the field, and then working for a governmental entity, you may not make as much money, but they were trying to bolster their people, their incoming people, so they start this internship program, and Mr. Schindel runs it for many years. And then Mr. Hamilton tells him, I'm relieving you of your duties under this program. We need a younger person in charge of this. Okay, he's the boss, but the younger person he put in charge of it were not qualified. They were not licensed professional geologists. They were geologists in training, but they were not licensed professional geologists, as was Mr. Schindel. So again, I think we have to add that into the age discrimination column. I mean, these are things that cannot be explained in another way. And John Craddock, another professional geologist that was forced out in his 60s, is the source of this. Now, as I said, if we go back to the 12B6 for just a moment, had Hamilton interviewed the 2 geologists that allegedly were placed in harm's way, he would have learned that they, quote, scoffed at the idea that they were in harm's way. Like I said, one stepped into a culvert 2 feet deep, squatted down, looked around. Is that a descent? No. Is that a descent? But she still had the ropes and the harnesses and the whole team around her anyway, because Mr. Schindel was mentoring her. The other geologist that made a 5-foot descent. And by 5 foot, I mean she went down 10 feet, but she was standing on the ground 10 feet below, and she's 5 feet tall, so there was 5 feet, she was 5 feet below the surface, still surrounded by her team upstairs and with harnesses and all the safety equipment, and she's the one that used the word scoffed, that was in any way dangerous. Her word was fun.
Your initial time has expired, and you've saved time for rebuttal. Thank you, Mr. Pina.
Thank you, sir.
Ms. Trejo?
Good morning. My name is Deborah Trejo, and I'm here to represent the Edwards Aquifer Authority, or the EAA. The EAA is a groundwater conservation district created by the Texas legislature in 1993 pursuant to the Texas Constitution to manage and regulate the Edwards Aquifer, a critical source of groundwater for people's homes, for businesses, cities, farmers, ranchers, and others in the South Central Texas region. It has professional staff dedicated to its mission of protecting the aquifer. Appellant, as you know, was a hydrogeologist who worked for the EAA. He has made serious allegations of age discrimination by the EAA in his amended complaint. But it is not enough for appellant to allege discrimination, as he has done. He must set forth factual allegations that raise a right to relief that is plausible, and ultimately he must prove that age discrimination was the cause of his demotion, which he has not done. In this case, there are no facts disputing that appellant was demoted immediately following a site inspection, during which he made the on-the-spot decision to send 2 staff members into sinkholes, a decision that EAA management disagreed with and which appellant still stands by. Appellant has also provided no evidence that the EAA's conduct towards him was sufficiently severe or pervasive to create a hostile work environment based on his age, or to show that he engaged in protected actions for which he was constructively discharged. Now, I want to quickly address some of the comments that were just made by appellant's counsel, which were not in the record at all and which are not accurate, including that there were comments made about Mr. Schindel being an old guy. That is not true. The only testimony about the comment "old guys" was made in Craddock's testimony, which is in the record, and he said those were general comments. He makes no temporal comments about when those were made by a supervisor, and they were not made about Schindel. There's no evidence of that whatsoever. There's no evidence that any decision makers at the EAA ever made any ageist comments, and no evidence that any decision makers at the EAA made ageist comments about Mr. Schindel. There was also a statement made that Mr. Hamilton specifically made ageist comments, which there's no evidence of. But it's really also that the internship that Mr. Schindel was told that was removed from him based on his age, which there's also no evidence in the record of. So these things are just new allegations being made here today, not in the record, and I think that's really critical to keep in mind. But what really sort of is very telling, I think, that none of this is connected and there's no evidence of age discrimination in this case, is that Mr. Schindel's testimony is that he worked at the EAA for more than 23 years and never once heard an ageist remark, which is why I'd like to quickly go over some of the chronology in the case, which I think really provides some clarity. When things happened, and the timing of events makes clear that appellant's loss of job responsibilities and demotion preceded his EEOC charge, alleging age discrimination, and that any issues concerning his loss of supervisory responsibility over interns or a peer review of the United States Fish and Wildlife Service technical report happened well before he resigned from the EAA. So first, and appellant's counsel mentioned this.
So that goes to the retaliation claim, right?
Yes. Yeah, for sure. In 2017, appellant was reassigned from Chief Technical Officer and Director of Aquifer Science to just Chief Technical Officer with no loss in pay. He was replaced by Steve Johnson, an EA employee who was 4 years older than him. So no evidence of age discrimination there. In 2019 and 2020, in this inspection of properties, including at the czar's property, The EA was updating its maps so that firefighters and others would know which way water would flow. If firefighters were out there fighting fires and water was flowing, would it recharge the aquifer? So the idea was go out there and figure out where recharge features are into the aquifer. It was not to enter caves or otherwise, put anyone in any kind of harm's way. It was an above-the-ground site inspection. At that inspection, Mr. Schindel directed 2 junior EA employees to enter sinkholes. When staff notified appellant supervisor, Mark Hamilton, who was also in the same protected age class and only 3 years younger than appellant, of appellant's actions, Mr. Hamilton ordered that the 2 employees exit the sinkholes. Just after that visit, EA's staff met with appellant to discuss what happened. Mr. Hamilton informed appellant that he believed the sinkhole entry was dangerous and not sanctioned by the EAA. Appellant disagreed that it was risky and also challenged his supervisor's competence to opine about the safety of the sinkhole entry. A few days after that, on December 19, 2019, the EA determined there should be disciplinary action, wrote up appellant's demotion. They determined that he had exercised poor judgment as to the dangerousness of sinkhole entry and disregard for authority.
Mr. Pina mentioned, I believe, at least twice that there was a failure to interview, 2 engineers? Mm-hmm. You heard what he had to say
Geologist.
about that?
Yeah.
Okay. A geologist, excuse me. How do you respond to that?
Well, I think they weren't interviewed before, but there were about 10 people out at the inspection. He mentioned that the geologists weren't interviewed. There were multiple other staff, environmental experts, supervisors who were out at the scene when this occurred. The fact of the matter is the EA has a policy against going into caves and sinkholes. And that policy was one that Mr. Schindel didn't agree with and instructed the staff to do that anyway. So there's a disagreement.
Schindel should have gotten permission once he got on site, but before he ordered that they descend into these sinkholes.
Yeah, I think there's an overall disagreement, and Mr. Schindel, too, today thinks that it's very safe and folks should be allowed to do it and it's a good experience. But that's not a disagreement about
I guess I'm just asking, was there some requirement, though, that before he dispatched him into the sinkhole that he get some other approval or permission to do it?
Even more than that, there was a belief among management that it was never proper to do, and that wasn't the purpose of the site inspection. So yes, for sure, if they were going to do it, but they wouldn't have said yes, basically, because it's just risk. There can be noxious gases. They didn't have all this equipment. There's no way to there's no machinery to pull them out. Anyway, So after that, the demotion became effective. He argued about the merits of the demotion, whether sinkhole entry was safe or not, whether he needed approval or not. He was then demoted, got a pay reduction, and then on March 17th, 2020, more than 3 months after, he for the first time raises the issue of age discrimination in his EOC complaint and says that he had been discriminated against based on an age-based hostile work environment and suffered this adverse action because of his age. On September 9th, 2021, a year and a half later, the United States Fish and Wildlife Service asked him to provide a peer review of a technical report involving the Edwards Aquifer. The EA approved appellant doing the review, but said that he must submit the draft review to the EAA before it got sent along to Fish and Wildlife Service. EA staff evaluated his review and provided comments and suggestions, including requesting that he omit certain changes into the document that they felt were not supported by the research. Appellant didn't agree to the suggestions from the EAA and didn't submit the review to the Fish and Wildlife Service, and then took no action against him. So it's then 7 months later, on April 22nd, 2022, that appellant resigns. There just simply is, there's a disagreement, and appellant has argued extensively about the facts of this case in the complaint and the briefing in here. But it's primarily about the fact that his demotion was an error. He's disputed that he should have been able to keep supervising interns and this technical changes to this document, but there's really nothing in the record other than vague statements by Mr. Craddock that Mr. Schindel didn't witness about old guys, really stray remarks. But however you view the merits of that site inspection, he has not met his burden to plead or provide sufficient evidence to support any of his age discrimination claims. There's really no there with respect to his claims of discrimination. Sorry, you're on.
Only one.
Okay. I wanted to just first address the claims dismissed by Judge Pulliam under 12b-6 for failure to state a claim. First, the hostile work environment claim. Appellant's complaint provided no factual allegations to support the claim that the EA's conduct toward him was sufficiently severe or pervasive to create a hostile work environment based on age. As the district court observed, the pleading merely describes actions that the EA has taken that appellant doesn't agree with. The actions that appellant disagrees with are that another EA employee who was older than appellant, Steve Johnson, was promoted to supervise him, and that the EAA asked appellant to make changes to the Fish and Wildlife Service document, which appellant said were not supported by the data and would put his geoscientist licensing at risk, changes which he did not make and for which the EAA provided no consequences, along with vague assertions by appellant that he was reprimanded by his supervisor without cause and that hostility toward older workers was palpable, none of which support a hostile work environment claim. The district court noted that appellant was unable to provide even a short or plain statement of the facts to support the hostile work environment claim. In fact, although the appellant worked at the EA for more than 20 years, his complaint makes clear that he could not provide a single example of an age-related slur that he experienced. Second, the retaliatory constructive discharge claim. He failed to plead as required that he engaged in a protected activity, such as complaining about age discrimination, that there was an adverse employment action making his working conditions so intolerable that a reasonable employee in the same position would be forced to resign, and that a causal link exists between the protected activity and the adverse employment action. Appellant was required to demonstrate a greater severity or pervasiveness of harassment than required for a hostile work environment claim, which minimum pleading standard he also could not meet. Now, appellant did not amend his EEOC charge to include a claim of retaliation on any basis. The complaint notes that appellant objected to the EA's comments on the Fish and Wildlife peer review, but he fails to allege that the EA requiring that he allow other staff to review and comment on a document to a federal agency created intolerable working conditions. And note, it took him 7 months after that incident, which the EA did nothing to him for not submitting it, to retire. The district court properly dismissed the retaliation claim because, as it said, appellant's complaint only briefly mentioned retaliation and provided no facts to establish the elements of a retaliation cause of action. He failed to plead or provide examples of the specific protected activity that he engaged in to oppose discrimination in the workplace, which could have given rise to the alleged retaliatory animus. Moreover, even if appellant had pled a specific protected activity that he engaged in, the timing doesn't work to state a causal link between the protected activity and the constructive discharge that he alleges occurred. The retirement didn't come until 7 months after the peer review issues. And as this court has said, close timing between an employee's protected activity and an adverse action against him may provide the causal connection required to make out a prima facie case of retaliation. And the Supreme Court has required that proximity must be very close, neither of which is the case here. Appellant simply didn't plead there was an adverse employment action that made his working conditions so intolerable. What he pled was, I was required to make changes to a Fish and Wildlife Service document, which he didn't make. So he simply also couldn't establish a causal link between that issue with the peer review and then his retirement 7 months later. So the dismissal for failure to state a claim should be affirmed on both hostile work environment and the retaliatory constructive discharge, leaving us with the last cause of action, which was dismissed on summary judgment. Summary judgment was appropriate to dismiss his discrimination claim under the ADEA, as there was no genuine issue of material fact that discrimination occurred, even with all evidence and all reasonable inferences drawn in appellant's favor. Applying the McDonnell-Douglas framework to his claim based on circumstantial evidence, appellant showed he's within the protected age group, he's qualified for the position, and he suffered the adverse employment action of demotion. But he couldn't show the fourth element, that he was replaced by someone younger or treated less favorably than similarly situated younger employees. He claims he met that fourth element by stating that the EAA removed the responsibility of supervising the internship program from him, and that Mr. Hamilton made a comment that appellant's responsibilities would be given to younger employees. However, the district court found that the removal of supervision of the internship program from him, which there's no date alleged when that occurred, didn't relate to his demotion after the SARS visit. And his declaration was insufficient to show that his demotion was based on age. The evidence is undisputed that the chief technical officer position was reclassified as a new position with different responsibilities and duties. And there's no evidence that all of his former duties were delegated to younger employees. There's also no evidence that any younger employee engaged in conduct nearly identical to appellant's and was treated more favorably. In all, he's been unable to point to any evidence in the record to show there's a material fact dispute regarding the fourth element. Nevertheless, the district court proceeded with the assumption that he had presented enough evidence to make a prima facie case. But even if this court determines that appellant has stated a prima facie case, the EAA provided a non-discriminatory reason for his demotion. He was demoted right after the SARS site inspection, at which the EAA determined he exercised poor judgment. He didn't test for air conditions. He didn't plan for this first. There were no safety protocols implemented. It was unnecessary for the purpose of the inspection. It's not sanctioned by the EAA. And after discussions of the inspection, he was defiant, and he refused to acknowledge the risks posed to staff by the subsurface entry. In response to the EA's expressed non-discriminatory reason for the demotion, he's offered no genuine issues of material fact to dispute the EA's reasons that would permit a jury to infer that his age was the but-for cause of his demotion, and that the EA's reasons were mere pretext for age discrimination. Even setting aside his failure to direct the district court to specific citations to meet this burden, which he was required to do, appellant's evidence merely disagrees with the EA's determination that he exercised poor judgment, making vague assertions about Mr. Hamilton taking bogus disciplinary actions against him, but entirely devoid of proof of discrimination. And in fact, the evidence shows the lack of any pretext in this case. Appellant's declaration admits he's recovered 5 dead bodies from sinkholes. And as the Fifth Circuit has said, management doesn't have to make proper decisions, only non-discriminatory ones, and even an incorrect belief that an employee's performance is inadequate constitutes a legitimate, non-discriminatory reason for termination. As I've indicated, there really is no proximity between the generalized comments that he talks about that were provided by Mr. Cradditt and the actions taken with respect to the SARS site inspection and his demotion. So he just simply cannot establish that anything that was done by the EA in response to the site visit or with respect to appellant at all had any basis in age discrimination. It's also important to note that all of the EA supervisors that have been complained of are in the same age class as appellant, making less likely his unsupported belief that age discrimination was at play. At best, appellant's claims of discrimination are based on conclusory allegations, improbable inferences, and unsupported speculation. And his pleading fails to allege valid claims for hostile work environment or retaliatory constructive discharge. The evidence shows there is no genuine issue of material fact that discrimination based on age occurred to support his claims of discrimination. The district court's order granting the EA's 12B6 motion and the EA's motion for summary judgment should thus be affirmed.
All right, thank you, Ms. Trejo. Mr. Pina, for rebuttal.
Yes, sir, very briefly, Your Honor. You know, with regard to not having raised the retaliation issue, the record excerpts at Exhibit 6, tab 10, is the EEOC charge. And the EEOC charge, which was done less than 3 months after his demotion, and his $50,000 downgrade and the loss of all his management functions. So 3 months later, he is claiming age and he is claiming retaliation to the EEOC. Now, and also, I believe I heard that learned opposing counsel saying that there was no temporal proximity between the downgrade, the $50,000 downgrade, and him being forced out or coerced into retirement, as he says it, when he was asked to rewrite a U.S. Fish and Wildlife study, a peer-reviewed document. He was asked to rewrite it to make EAA look better, more compliant. But in Mr. Schindel's professional opinion, as a professional geoscientist, it was not supported. The rewrites that Hamilton wanted were not supported by the geoscience data. And as a result, he goes so far as to check with his licensing authority in hypothetical terms and explain the predicament, explain the situation. And they told him in no uncertain terms, hypothetically, that if he were to rewrite a peer-reviewed study that is not backed by the geoscience reflected in the peer-reviewed study, that he could be subject to loss of his license or other disciplinary matter. And that's when he said that it was a Hobson's choice, no choice at all. The choice was he would be terminated by someone who has shown a negative animus towards him for some time, or possible loss of his license if he complies with his boss's demand that he rewrite a peer-reviewed study. So I think that was what forced him out, and that is in the record also. That is the very last document in our record on appeal. In our record excerpts. It's the very last document. You'll see Mr. Schindel's letter to the Edwards Aquifer Authority saying, I can't do this. I can't rewrite a peer-reviewed study and face disciplinary conduct from my licensing authority or termination from you. I am resigning. I am exercising my right to, at age 64, retire early. So there's significant evidence that should have clearly passed the 12B6 test. It should have passed the motion for summary judgment. The fact that Hamilton, the alleged discriminating official here, does not tell Mr. Schindel these ageisms is not much of a defense, because he was saying it to others in their 60s. And that's how he learned about it. Yes, that's right. He didn't learn about it. He was never called an old man or told that we needed to get new blood in here or the other ageisms that are in the record by Hamilton. But he did learn about it during the discovery process, and that's why it's in the summary judgment record. So this case should be remanded. I respectfully, urgently plead that this court remand.
All right. Thank you, Mr. Pina. Your case is under submission. Last case for today, Reed versus Marshall.